I had a gentleman who is in his mid-30s, had a 5-year-old daughter in the car with him. He and his wife were separated. Actually, they're going through it was a pretty nasty divorce. And this was in felony court because anytime you're arrested under suspicion of DWI with a child who's 14 or younger in the car, it's an endangering, or it can be a DWI with child passenger, and it automatically becomes a felony on the first offense. He took a breath test and blew a .19, which is over double the legal limit. His family law attorney kept calling me, asking me what was going to be the outcome of the case, because they assumed it would be a guilty verdict. They had some pretty damaging evidence against my client. The family law attorneys for my client's ex-wife, or soon-to-be ex-wife, they wanted to keep pushing back the child custody hearing until he was convicted, because they were sure that he would be convicted. Once he was convicted in felony court, then the mother would be able to have custody. It would have been an easy battle. Well, it took about 1.5 years. There was an election, and a very fair judge was elected into office in this court. We did go to trial, and I brought up a lot of suppression issues with the way the breath test was taken, the way the field sobriety tests were performed, and basically I was able to show the judge that the field sobriety tests were not performed in accordance with the guidelines that they were supposed to be, and this is what the probable cause was based on for the arrest. And after that, I was able to show that the breath test was not admissible according to the laws of the state. Basically, we got all of their evidence suppressed, and we won the case. And the family law attorneys were perplexed after that. But it was the right outcome. Even though they had some bad evidence against them, it was not obtained legally.